right, we are live.
Good morning, everyone, and welcome to the May 4th, 2020 of the Massachusetts Appeals Court. I'm Justice Eric Neyman, and sitting with me today is Justice John Englander and Justice Catherine Hand, and we will be your panel for today. Normal appellate court rules will apply, but first let me remind you that this proceeding is live. Anything said during the proceeding may be overheard by all of those observing and will be seen by observers on the court's YouTube channel. The proceedings are being recorded, and of course, courtroom decorum rules still apply. With that said, each side, per our normal rules, will have 15 minutes to present argument. In the appeals court, there is no rebuttal. I can assure you that we have read the briefs, we have taken a look at the case law, we are intimately familiar with the appellate record. So I would encourage counsel to use your 15 minutes wisely and cut to the best part of your argument. But of course, your time is yours to use as you see fit. So with that, we'll call our first case, Patel versus Banville, 2019 P1237. And we will hear first from the appellant. And will counsel please introduce himself for the record?
Honor Stephen Kafori on behalf of the plaintiff appellant, excuse me, Mrs. Patel. May it please the court. Thank you, first of all, for allowing us to move forward in these unusual conditions. My client sincerely appreciates that the panel is hearing cases. As this honorable court is aware, we're here today appealing a grant of dismissal per Rule 12b-6 for failure to state a claim upon which relief can be granted. The plaintiff in this underlying matter contends that the complaint as construed is fully compliant with Rule 8a of the Mass Rules of Civil Procedure and contains sufficient factual allegations which, taken as true with favorable and reasonable inferences drawn in the plaintiff's favor, constitute plain statements that do carry enough heft to plausibly suggest an entitlement to relief under a theory of negligence pursuant to Chapter 229, Sections 2 and 6 regarding conscious pain and suffering and wrongful death. I really believe—
the sidewalk.
Sorry?
Who owns the sidewalk?
The city. City of Pittsburgh in the case.
Sorry, I lost your counsel. I apologize.
Who owns the sidewalk? The city of Fitchburg owns the sidewalk. Westminster Street is the sidewalk in question.
Right. So if the city owns the sidewalk and that's conceded by the plaintiff, how do you avoid the Halbeck case?
I first look to the Mays and Pritchard cases, Your Honor, where there's a duty to refrain from creating a hazardous condition on an abutting public way.
Where does your complaint allege that the hazard was created by the plaintiff?
So if we're just to look at count 3, paragraphs 4 through 8, because if you look at count 4, 5, and 6, we're considering the same numerical paragraphs here. But, paragraph 4 notes the date and time of this incident, and it indicates the condition of the sidewalk location immediately adjacent to or being a part of the premises of the named defendants in this matter, who were granted dismissal. It notes that it was snow covered and impassable. He was forced to walk along the roadway edge in the breakdown lane of Westminster Street. Now, the subsequent paragraphs indicate that the defendant failed to essentially alleviate this condition and allowed it to remain right on the edge of its property where its parking lot means of egress is located. And essentially, if you look at paragraphs 4 through 8, we're alleging that due to the defendant's negligence by creating this condition on the public way of Westminster Street, the condition was that it was snow covered and impassable, and they allowed it to remain as such. It interfered with the safety and convenience of travelers on the public way, such as the plaintiff's decedent. And because of
Doesn't-
that,
I'm sorry to interrupt, but doesn't our case law require that you create the condition, not merely do something about it? So in other words,
exactly,
had someone attempted to shovel and taken all of the snow and shoveled it onto the sidewalk, thereby making it impassable, that would be creating the condition. But here, I don't see any allegations in the complaint of such creation, if you will.
upon review of photographs taken by the police, to give proper context, Judge, upon photographs taken by the police the night of the incident, it's clear that what happened was the parking lot and entranceway was plowed. And when the entranceway was plowed, it caused a buildup onto the sidewalk of more snow.
Okay, counsel,
Okay,
that's a very legitimate claim that is not in your complaint.
That was my question. Where can I find that in the complaint?
And the issue I have, to build on what Judge Neyman just asked, is it had to be apparent to you folks that this is where you needed to be when you were in the trial court, confronted with the motion to dismiss that raised these arguments. And an opposite, at that point, if you wanted to amend your complaint and say you created the condition, here are, I mean, you don't even, on a complaint, you don't even have to put in photographs. But the time to do that was in the trial court, it seems to me. I understand you want to draw our attention to paragraphs 4 through 8, but I'm having difficulty finding the allegation. I can't find the word created. I'll tell you that.
So in paragraph 3 of the same count, it alleges the ownership and control of the defendant's premises, including its exterior grounds and the store and the stand, the farm stand, excuse me. Now, in just for example, Judge, there's paragraphs 6 and 7 indicate that or allege that the injury was caused by the carelessness and negligence of the defendants or their agents, servants, etc., by its allowance of the dangerous condition to remain and exist on the premises referred to in the earlier paragraphs, which, if we go to paragraph 4, indicates the location immediately adjacent to or being a part of the premises of the defendant at 85
That's a little
Westminster
bit confusing, right? Allowing a dangerous condition on their own premises is irrelevant because, as you've just told us, the sidewalk is owned by the city. So how are we to understand that to be saying that they created a dangerous condition on the premises of another, which is what you're telling us is how we should understand these paragraphs?
Yeah, so I understand, Judge, but I go back to paragraph 4 where it indicates, because the issue here is that the point of impact of the ultimately fatal accident, based on the police reports, is right at the entranceway to the parking lot. So it's not entirely clear, absent discovery, whether it's on the parking lot entranceway or it's at the sidewalk area right before it. So that's why paragraph 4 of the complaint is drafted as such, because it encapsulates both areas in question, which, absent discovery, we need to get to the crux of the matter. So if in fact it was on the sidewalk, the allegation is that the defendant was negligent because of the...
I misunderstood then. I thought the allegation was that the decedent was struck on a public way, and that the allegation against these defendants is by not clearing the sidewalk, that person walked on the public way.
Well, he was struck on a public way, which he was forced to walk on because this subject area, this exact locus, was snow covered and impassable, which we allege is due to the negligence of the defendant, essentially in their failure to remove this condition that we believe was created by the defendant.
Hey. Just, counsel, just asking us to read an awful lot into language of this. Okay.
Is your best case the Lindor versus McDonald's case, or are you relying on something else?
The Lindor versus McDonald's case is certainly helpful because it does articulate a sidewalk near a defendant's restaurant where someone slipped and fell. I believe the opinion in that case is not precise as to where exactly the sidewalk is located, but nevertheless, there were sufficient facts in that case whereby, excuse me, summary judgment was remanded because of the lack of the defendant's maintenance of this slippery sidewalk where someone ultimately fell and was injured. But I also point to the Pritchard case, which is another snow and ice case where the opinion noted that the duty is to refrain from maintaining conditions which will interfere with the safety and convenience of travelers on a public way, which I believe is directly on point to the facts alleged in the complaint in this case. The interference with safety and convenience of a traveler on a public way. Because he couldn't, essentially because his method of moving forward was interfered with, he had to go around and was struck. The Mays case also indicates that you must refrain, the defendant landowner must refrain from causing injury to a traveler on an adjoining way. I know that the rule is pretty clear as to that it's a negative duty, a duty to refrain, but nevertheless, there's a duty there. And I would just like to note, there are many cases that both parties cite that are seemingly more favorable or less favorable to each party, of course, but each of these cases, I believe the overwhelming majority of them made it to trial, or at least made it to summary judgment, where discovery was exchanged to determine whether or not, even the Halbach case made it to summary judgment. And I think that the facts in that case are much more favorable to the defendant in that matter. In the Halbach case, the defendant refrained from any action before the incident occurred and then essentially did a good deed to grind down the sidewalk after the fact. But they refrained from creating any condition in that case. It was uneven pavement on the sidewalk on Clarendon Street. But even that case made it to a Rule 56 hearing. And there are other cases where individuals just slipped and fell on black ice and there was no meddling by the abutting landowner. I think that the Mahoney case cited by my sister was a 1931 case. That case went to trial. These negligence cases went to trial, or at least summary judgment cited in the briefs. So I think that's an important fact where if the case pleads out a claim for negligence, and if discovery can be exchanged, certainly if appropriate, a Rule 56 hearing could be held on this matter down the road. But certainly, of course, that depends on what comes out through discovery of this matter. And then
were these arguments made to the trial court? Where would I find this argument in your opposition to the motion to dismiss filed below?
I would look to the record appendix, page A186. It's a transcript from the lower court motion hearing. I know that the defendant's brief in this matter notes that for the first time, the plaintiff makes the allegation of the creation of the condition, but it's not true. It's the first thing that was addressed in the argument at the lower court's motion hearing, and it was really the crux of the argument at the lower level. But the
judge say, I can't find that in the complaint?
I don't recall off the top of my head, Judge.
At the end of the day, our review is de novo anyway, so it's either in the complaint or it's not, correct?
That's correct, Your Honor. And I believe that the complaint makes out a claim for negligence here, and what the negligence claim is that it's the duty to refrain from creating a dangerous condition on an abutting public way. So if that's in fact
the Wizard of Oz look that I've got going, it has to do with the sunlight coming through the window. I'm sorry, folks.
No worries. I know that my time is running out. I'd just like to quickly change gears here and note that there are arguments in the briefs on foreseeability. And I would just like to point out that I don't know that foreseeability is appropriate at this stage because it's generally a question of fact for the jury, the issue of foreseeability and proximate cause. First and foremost, I know that that is not an absolute rule, but I would say that generally that is a question of fact for the jury. Now, there are arguments in the briefs addressing whether or not it's reasonably foreseeable absent a record of evidence through discovery, so I think it's premature. However, I point to the Soderbergh case regarding the foreseeability, not just concerning slip and falls, but just more so for the point that there's a quote in that opinion noting that our case law in Massachusetts is replete with examples of people who, upon encountering snow and ice hazards, nevertheless continue to venture forward in the belief that they could do so safely if they proceed with care. It demonstrates
law, though, isn't it, counsel? I mean, isn't proximate cause a question of law? Ultimately, it's the extent of the duty.
Ultimately, yes, but the issue of causation is often a question of fact for the jury, and especially in negligence cases where there are very often disputed issues of fact. So I think the Soderbergh case is on point here, noting that it's foreseeable that people will engage snow and ice hazards, which I think occurred here. The individual, the plaintiff's decedent, ultimately engaged a snow and ice hazard and continued forward rather than turn around and go back. So that's all I'd like to say on the foreseeability aspect here, but I know that my time is up. I thank you all for your questions and for considering the plaintiff's appeal of this matter. If there are any questions, I'll certainly take them, but I know that my time is up. Thank you.
Thank you, counsel. Let me just check. Justice Hand, any further questions?
No, thank you.
Justice Englander?
Nope.
Okay, thank you very much, counsel. We appreciate your argument. We will now hear from the appellee, represented by Attorney Parker.
Thank you, Your Honor. This is a simple case. It involves one issue and one well-established rule of law, and that is, as this court is well aware, a property owner does not have a duty to maintain a public sidewalk which abuts his property free of ice and snow.
So that immediately begs two questions. First one for me is, as Attorney Kafori stated, almost all of the cases cited in both of your briefs involved either a ruling after trial or a ruling after summary judgment. So was it premature to allow the motion to dismiss here? Because again, we are obligated to accept all of the averments as true, including all the reasonable inferences drawn therefrom. And then I'll get to the next question.
Thank you. No, it was not premature. The decision was a correct decision based on the allegations in the complaint, which I know the court has looked at extensively here, but there is nothing in the factual record to suggest that the defendant somehow placed snow onto the sidewalk. That did not come up until this appeal. And in fact, I would like to point out,
counsel just represented that it was argued below to the judge.
So below, it was he argued that it was possible that, actually I can get it out, I have the transcript right here. But if a hazard is created by pushing snow onto the way to create impassable, the plaintiff contends that's negligent maintenance of the defendant's property. But he never came out and actually said the defendant in this case negligently plowed snow onto the sidewalk. And I would further note, if you look at the record appendix beyond the complaint.
From what page?
I'm sorry, I was reading from page A192 of the transcript. And if I may also note page A133, which is the police narrative that was submitted with the plaintiff's opposition in the Superior Court. That police narrative specifically states sidewalk down to bridge and along front of mill number 3. Mill number 3 is obviously the defendant's property, was not shoveled, not passable for foot traffic.
Yeah, but now you're going outside the record. The question is, what is in the complaint? He says you can find it in the complaint. Granted, the word created is not there. But then we have circumstances where he says the argument was made below that that's the fair reading of my complaint, is that I've alleged that the snow was put there by the defendant. And you read from A192?
Yes, Your Honor.
That's the only place where it's referenced? Okay.
That's the portion that I read that was most closely related to the argument that they're making now, having to do with plowing the snow onto the sidewalk. But that's not what the allegations were in the complaint. And as Your Honor earlier pointed out, the complaint is.
I'm not quite sure what the right answer to this question is, but let's say that there's maybe a little bit of fuzziness in the complaint. I apologize. This sun is going to go away shortly. It's moving across the sky. And you go into a motion to dismiss and the plaintiff says, basically, this is the way to read my complaint. Now, at that point, the judge could allow an amendment, or they could accept that that's the allegation, it seems to me. But to ignore that that's the allegation strikes me as maybe a little bit too harsh. Help me with that. How do we do it? If the plaintiff says the way to read this is that it was created by the defendant.
Well, the fact is the plaintiff's complaint does not say that it was created by the defendant. The plaintiff's complaint says that the sidewalk was impassable because the defendant failed to remove snow from the sidewalk, and that's what forced the plaintiff's decedent to walk in the street. That's what the plaintiff's complaint says.
Your brother referenced
Repeatedly.
your brother referenced the police report. Was that attached to the complaint?
So if you look at the police narrative at A133, to answer your question, no, it was not attached to the complaint.
Okay, thank you.
Correct. It was attached to the opposition in the trial court below, but it absolutely was not attached to the complaint.
It was
At the end of
the opposition?
So, right, the police report was attached to the opposition, and that's why I directed the court to the record appendix A133, which describes that the sidewalk, the entire sidewalk from the bridge down along the front of the mill was not shoveled. There is nothing to suggest anything having to do with plowing. In fact, this is a case that is about failure to remove snow altogether.
You can't read the negative implication at a motion to dismiss stage into the police report and take that as meaning that the police are saying that he didn't put snow onto the sidewalk.
I just note it's just one more example where there was no mention of any sort of allegation that the defendant plowed snow onto the sidewalk and caused a condition where the plaintiff could not, or the plaintiff's decedent could not walk on the sidewalk. Rather, the allegation
is there a city of Fitchburg ordinance with respect to clearing sidewalks? I saw an allegation later on in the complaint about it having to do with the city of Fitchburg. But, well, first of all, is there an ordinance? Secondly, is the ordinance anywhere in the record?
Yes, Your Honor, there is an ordinance with the city of Fitchburg. The actual ordinance itself does not appear in the record appendix. However, it is noted in the plaintiff's complaint. And essentially the city of Fitchburg ordinance requires the city to perform snow removal of sidewalks on certain streets, one of those streets being Westminster Street, which is the street at issue in this case. So that is noted in the plaintiff's complaint.
So the ordinance itself doesn't require it's not like the city of Boston ordinance that requires people abutting the sidewalks to clear their own sidewalks.
That's correct, Your Honor, with respect to certain streets. So in this case, Westminster Street, that's the city's responsibility.
Okay.
Correct.
How would you distinguish the Lindor versus McDonald's case?
I distinguish the Lindor versus McDonald's case because the sidewalk at issue there was no argument having to do with it being a public sidewalk. In fact, it was a sidewalk that was on the defendant's property involving a person who was visiting McDonald's, for the purpose of obviously going to that establishment. In this case, we have an individual who is a passerby who happens to be walking along the street in front of the defendant's property with no alleged intention of visiting the defendant's property, which was a farm stand business.
So what if the facts of this case were exactly the same, but the allegation in the complaint was that the plaintiff had just left defendant's building as an invitee and slipped and fell and was injured on the exact same piece of sidewalk?
Well, it would be different because the plaintiff was actually, in this case, even if he had been a visitor of the defendant's business, in this case, he was struck by a car on the street. He did not slip and fall on the sidewalk.
Then let me rephrase. If he slipped and fell because he couldn't walk safely on the sidewalk adjacent to the defendant's property.
It's still the same, because at the end of the day, there's the well-established public sidewalk rule in case after case after case, where courts have held that the defendant property owner does not have a duty to maintain the sidewalk free of snow and ice. So the rule still applies.
And you're saying Lindor is very clear that that sidewalk was not a public sidewalk in that case? It was on McDonald's property? Is it that specific?
I believe so. That was my reading of it. It's certainly, there was no allegation that it was a public sidewalk. It was just a sidewalk near the restaurant.
Okay, I was under the impression that that case turned the ingress and egress into McDonald's as opposed to it being public versus private, but I'll take another look at it.
And he makes the following statement in the argument to Judge Green. I'm on page 187. A landowner does, however, have a duty to maintain its premise in a safe condition so as not to create an unsafe condition on a public way or sidewalk. Court, right, but the premises refers to the land that's owned by the landowner as opposed to the public sidewalk, correct? Answer, that's right. So how does that help you? Answer, that it's possible based on photos from the police department that snow was further pushed into the street and the sidewalk, creating, and the court interrupts and says, what have you alleged in your complaint to that effect, if anything? Answer, just the negligence and carelessness of the defendant to maintain his premises. Is it possible we're parsing this a little too fine?
I think it is possible. I also want to note, again, it's not alleged in the complaint, as we discussed at length, but there's also case law out there. If you look at the Gamir versus 236 Commonwealth Ave Condominium Association case from 1985 that was decided by the appeals court, which is very on point with this issue. One of the things that was argued in that case was that the defendant had actually shoveled an area of the sidewalk and had put snow on the side of the sidewalk, and that the snow melted and it created an icy condition on the sidewalk, which is what caused the plaintiff to fall. And the court said the defendant's action of moving snow to the side of the sidewalk did not create liability in that case. And it held fast to the public sidewalk rule.
I'm sorry.
I'm sorry? I'm sorry.
What was the site that you just, what case?
Certainly, it's Gamir versus 236 Commonwealth Ave Condominium Association, 19 Mass App Court 359. So that case suggests that snow removal efforts, when it comes to a public way or public sidewalk, do not create liability on the part of a defendant property owner.
About where somebody's house overhung a public sidewalk and stuff dripped off the house and froze, and that was sufficient for liability?
That was sufficient for liability. That was different. There was a condition of the defendant's property that caused water to drip onto the sidewalk, thereby creating the condition.
How is that different than to shovel your own sidewalk and therefore cause a condition to occur on the sidewalk itself? I'm sorry, shovel your own driveway and cause a condition to occur on the sidewalk.
Well, the difference is, first, the snowfall that has happened, obviously the defendant did not create the snowfall. Rather, the defendant is attempting to mitigate that by removing the snow and, in the Gamir case, placing it on the side of the sidewalk, as opposed to it being sort of a condition of the property causing something to spill out onto the sidewalk, so to speak.
I'll read the case. Let me ask you this. Your foreseeability argument about basically your proximate cause argument. Isn't it foreseeable that if in fact you created a problem on the public sidewalk, so it was, just assume with me that he created the problem, your client, so that it was impassable. Isn't it foreseeable that someone could get injured thereby when they had to walk in the street?
It's not foreseeable that someone would be walking in the street at 6:30 at night on a January night and would be struck by a speeding vehicle.
What's the purpose of having a sidewalk?
To allow
People walk in the street, right?
I don't disagree. Obviously, the purpose of the sidewalk is to allow people to walk somewhere that is not the street, but it's not foreseeable to the defendant that the failure to remove snow from the sidewalk would result in someone being hit by a car in the street as a result of walking.
That's an intervening cause argument, right?
I'm sorry?
To me, that's more or less an intervening cause argument, that the behavior of the driver, who was also a defendant here, is what cuts off any possible liability for your client as a landowner.
I would agree with that. More of an intervening or superseding cause. The speeding driver hitting the decedent as he was walking down the street is the cause of the injury in this case.
Hey, counsel.
Oh,
I'm
sorry.
sorry, your time has expired, but Justice Englander appears to have another question.
No, I'm fine. Thank you.
Justice Hand?
No, thank you.
Okay. Thank you very much, both counsel, for your helpful briefs and your excellent arguments, and the case is submitted.
There's some feedback happening.
Better?
That is better. I think it's better if you stay closer to the screen,
Okay.
or to the microphone, I should say.
Thank
All right,
you.
we are live streaming.
Okay, we are calling our second case today, 2019 P1165 Care One Management versus Gloria Brown. And I would remind counsel, as you're well aware, that we are being live streamed. You are being recorded. So I would ask you to conduct yourselves accordingly. Thank you for participating in this virtual hearing. We will hear first from counsel for the appellant.
Thank you, Your Honor. My name is Andrew Cohen. I'm a legal services attorney at Health Law Advocates. I represent Gloria Brown individually and as representing the estate of George Brown. May it please the court. This case involves Mrs. Brown's motion to vacate a default judgment for her late husband's disputed debt to a nursing facility. The trial court weighed all the relevant evidence, applied the correct legal standard, and found she deserved a trial on the merits despite procedural delays. Then, inexplicably, the judge imposed a vacator condition that was improper, out of phase with state and federal law, and disproportionately unfair to Mrs. Brown.
Mr. Cohen, can I stop you? And I have a preliminary question.
Yes, Your Honor.
So this is a motion to remove a default judgment, correct?
Yes, Your Honor.
And the judge has a lot of discretion in making these determinations. And would it be fair to say that the judge here, had he wanted to do so, could have used his discretion to say, I'm denying the motion outright, to remove the default judgment?
Yes, Your Honor, it is an abuse of discretion standard. And had the record convinced the judge that that was the correct outcome, the judge certainly could have made that decision.
So let me stop you right there. If the judge has discretion to deny the motion to remove the default judgment, in other words, to say to your client, sorry, no excusable neglect, you haven't met the standard, you are out of luck, you have no case. If the judge had that discretion, how can it be an abuse of discretion to allow her motion, but doing so by imposing a condition? Do you follow the logic of my question?
I believe so, Your Honor. Here, the abuse of discretion standard that you discuss is the right one to apply. Yes, the judge has discretion. However, the discretion has limits. As stated in Dimanche v. MBTA, these conditions on vacator should be curative measures that remedy actual prejudice to the non-moving party or address culpable conduct by the movement. And here, the judge actually found excusable neglect because there was no prejudice to the non-moving party. They didn't even allege any prejudice to themselves. And when we speak about prejudice—
Do they have to allege prejudice to themselves? I don't— At what point? Your client is the moving party, right? So why is it they have to allege prejudice?
They don't necessarily need to allege prejudice, Your Honor, but there needs to be a showing of prejudice, such as loss of evidence, discovery difficulties, enhanced opportunity for fraud and collusion.
Couldn't
On the
the
record,
judge figure out on his own that there was an issue with evidence being lost? If you look at the allegations that were being made in the motion for relief, including that the husband had been mistreated by the nursing home.
could you please clarify your question, the Honor, about the loss of evidence?
Yeah, I apologize. It's hard to hear me because it turns out that if I move forward closer to my microphone, I will lose my video. So I will do that now, but I'm just explaining why I'm doing this. Or maybe not, maybe it'll stay. The judge mentions the word stale. Right? In the allegations in the motion to dismiss, in the motion for relief itself, part of the allegations are that the nursing home mistreated the husband, did a number of things that were improper in terms of care. Can't the judge infer from that that having waited now over a year, the evidence might be more stale?
Yes, the judge could infer this, but actually the prejudice in that case would all run against Mrs. Brown, not against the facility itself.
I don't understand that. Both parties would have difficulty potentially getting to evidence that could affect either the plaintiff or the defendant. I mean, the defendant may have had, so Mrs. Brown says you put a catheter in that you weren't supposed to put in, all right? Well, maybe the person who did that has now left the defendant and is unavailable.
Mm-hmm.
So it can prejudice both parties, right?
Yes, Your Honor, it could prejudice both parties. But here it's very clear that the prejudice runs much deeper against Mrs. Brown. And a very important point is that the judge actually, in imposing the sanction itself, that was the abuse of discretion. The abuse of discretion was not finding excusable neglect. It was actually doing a sanction that was not supported by the evidence at hand. There may have been inferred prejudice, but the prejudice identified, there was no specific prejudice identified by the judge. The only prejudice was delay, but delay in and of itself is not prejudice, as the KPS v. Design Systems case from 2003 First Circuit says. What you're really looking at is exactly the issues that you're discussing, Your Honor, about loss of evidence, discovery difficulties, and potential for fraud and collusion. Here, there's no evidence of fraud or collusion, for example. The delay was all based on good faith factors. Good faith factors that the judge found in terms of her own illness and her husband's illness and his eventual death.
So basically, that's an argument that as a matter of law, this sanction was unavailable to the court.
Yes, Your Honor.
Or are you saying the court needed to take further evidence before, because he's concerned about staleness. He uses that word in the order. Why isn't that within the discretion of the court, given the pleadings before it?
Staleness, Your Honor, really goes to the question of the statute of limitations. And here, her statute of limitations had not run on the negligence claims.
Staleness can mean a lack of evidence, just as you identified something that could be a concern.
The judge did not indicate in the opinion, Your Honor, any specific lack of evidence. On the contrary, the judge actually had very robust findings, but all of the robust findings went in favor of Mrs. Brown. And in theory, there might be questions of evidence, but that should be best resolved by the trial court itself. The abuse of discretion created a situation where she really had to choose. It was an improper choice that was foisted upon a pro se plaintiff.
Let me ask you this, counsel. The claims that eventually, so the contention here is that certain claims have been denied to your client, right? Or,
Your Honor.
The availability of remedies beyond the value have been denied.
Yes, Your Honor.
Was that a compulsory counterclaim?
I believe it would be, because it arises out of the same locus of facts that the admission agreement and that the stay for care did.
Okay. So as Judge Neyman pointed out right at the top, your client not having answered at all, those compulsory counterclaims would have been lost completely. Now they're being given back, at least in part.
Respectfully, Your Honor, she actually did attempt to answer by sending answers to the other side's attorneys. However, she did not file an answer with the court. That is true. She
Did her answer contain any compulsory counterclaims?
I'm sorry, Your Honor.
The answer that you allege was sent to the other side, but not filed. Did it contain the counterclaims?
Your Honor, we do not have a complete version of that answer on record. There is a partial version on record. I believe it is at Joint Appendix 350 or I think it's 350. But there's also evidence in the record that she provided the answer multiple times to that party, to the other party's attorney. You can see Joint Appendix 250 to 251. There's a cover letter to an answer. The answer itself is not included. And there's also her testimony during the October 3rd, 2017 hearing at Joint Appendix 280 to 281.
What was the first number you gave me?
The first number was Joint Appendix 350, and then there's Joint Appendix 337. Let me see. Oh, yes. I apologize, Your Honor. It's Joint Appendix 326 to 329, the partial copy of the answers, 326 to 329.
Okay.
But the real key issue here is what the judge actually found. The judge found excusable neglect. So it is true that she did not file the answer with the court, but the judge excused that, finding that it was not in bad faith. It was her delay was actually caused by her own illnesses, her hospitalization, her husband's illnesses and death.
What is your best? I'm sorry. What is your best case apart from Demanche for the proposition that this condition just simply goes too far?
Another excellent case would go back to Thorpe v. Thorpe. It's really a key case from 1966, the DC Circuit. And it talked about an extraordinary condition. And the extraordinary condition was actually financial in nature. And it put the parties at a status quo ante, which was found to be inappropriate in that case. Now, another case is Wokan v. Aladdin, a Third Circuit case from, I believe, 1973. And there, again, it was an unusual condition that ended up putting the other party against whom the condition was not levied in a better position than they were beforehand, before the judge made the decision with the condition. That's similar to what happened here. In some ways, you can look at the condition as a damage cap, because what the judge is saying is you cannot recoup any damages beyond the amount of liability you have to Care One. if in fact she fully defended her case and she has full defenses against this claim, she would be denied any recovery at all, essentially cutting off her claims entirely.
And I'm confident that Justice Englander would like to hear your views on the DeMonch case.
Yes, Your Honor.
You know, the key to that case
Actually,
is,
that part of the DeMonch case got it right. It's when they decided not to give us any relief that they got it wrong.
I completely agree with you, Your Honor.
it seems to me
Thank you,
that in
thank you.
DeMonch,
Thank you, counsel.
it seems to me that in DeMonch, though, the key to that case, it really hinged on the punitive nature of the condition.
Yes.
And it's tough to read tone into a judge's order, but the order here did not seem punitive in nature. It seemed it was a judge who was really wrestling with fairness for both parties and trying to carve out a solution that was just for all. So I think it's distinguishable from DeMonch, but perhaps you have a different perspective.
I agree with you that you can't necessarily read bad intention. I don't think the judge was bad intentioned, but I think the result was disproportionately punitive and prejudicial to Mrs. Brown. She's the one that ended up with a $72,000 lien on her family home and no opportunity to ever raise her defenses.
Well, let me just interrupt you there, counsel, because there's one other sort of elephant in the room here, which is she did try to bring that lawsuit and it was dismissed. So wasn't it dismissed with prejudice?
Yes, Your Honor, but she only raised certain claims in that other lawsuit that all were around negligence and medical malpractice. That is what was dismissed. She has several other claims, including unfair and deceptive acts and practices, violation of the Attorney General's regulations under 93A.
What about res judicata? Didn't she have to bring all those claims at the same time?
You know, res judicata is a equitable doctrine. In this case, the equities really run in Mrs. Brown's favor. And we think the best result and the most sensible result.
An exception because we just shouldn't apply res judicata to Mrs. Brown.
No, Your Honor. Res judicata could be raised by the other party as an affirmative defense under Rule 8. If it is remanded back to the trial court, allow her to provide her answer, allow her to bring those counterclaims, and then the trial judge is really in the best position to decide on that matter. That other case would not exist but for the abuse of discretion in this matter here, putting Mrs. Brown in an untenable position of making a choice.
So we don't have in the record what the reasons were given for the motion to dismiss that was filed in Mrs. Brown's separate wrongful death case. Did they argue that it was a compulsory counterclaim in this case and therefore ought to be dismissed?
They did not, Your Honor. The second page of the motion raised other issues that did not raise res judicata and did not raise compulsory counterclaims.
I have one final question. Assume, and this is truly just an assumption, assume for the sake of argument, we determined the condition to be unreasonable and we remanded. What would be a reasonable condition under these circumstances, particularly where your client said repeatedly she has no money, no ability to really do very much to assure the court, to allay the court's concerns?
On these facts, Your Honor, no condition would be reasonable because the facts all run in Mrs. Brown's favor. Now, in theory, there could be a financial condition, but it would really, the Paul Corp case in the Eastern District of New York found that a financial condition may not be reasonable in certain instances where there really is no prejudice and where there is no bad faith. I see my time has expired. I thank the court and thank you, Your Honors, for this opportunity.
Okay, let me just check. Justice Englander, any further questions?
Well, I guess the only thing I'm thinking is when you say that all of the equities run in Ms. Brown's favor, isn't there a delay piece to this that is actually running in the other direction?
There is delay, Your Honor, but in the words of KPS v. Design Systems, delay in and of itself is not prejudice. It really does have to go to what we were discussing before about the loss of evidence.
Right. I mean, the entire purpose of the 20 days to answer is in order to move the litigation along at some reasonable pace. Your client failed to do that. It took another 8 months for your client to seek to reopen. how can it not be prejudicial to a plaintiff who was out $70,000 not to get their money? I don't understand that. Is that what the First Circuit said?
The judge himself in this case, Your Honor, found that the delay did not warrant, actually was excusable neglect. And the trial judge, in very carefully weighing the factors, determined that the excusable neglect ran in Mrs. Brown's favor and not for the other side.
Thank you, counsel.
Justice Hand, any further questions?
No, thank you.
Okay, thank you, counsel. And we'll now hear from counsel for the appellee.
Morning, may it please the court. Tori Wiegand for Care One. Conditioning the vacating of the default judgment on limiting the value of the affirmative counterclaims was well within the considerable discretion, given that it would not have been an abuse of discretion to deny this motion outright. And I think it's important when you consider this case to look at both the order and the hearing. This judge was intimately familiar with this case. It had reviewed the prior attachment hearing and ruling. It held the hearing on the assessment of damages. It held the hearing on the Rule 60B motion, reviewed the briefing. It asked for supplemental submissions after the hearing. It reviewed that. It recognized the applicable law, the Ruby factors providing some guidance. It recognized the policy favoring merits consideration, and it recognized it had the right to impose just conditions. It took all that into consideration, and when you look at the hearing and you look at the order, it says it was a close one.
Did your office receive the answer that we were just pointed to at A226 to 229?
I looked for that. I am new counsel to this. My office took over later, I think at the time of the Rule 60B motion. From what I have in my record, I just have what you have in the joint appendix. It looks like there's a letter addressed to prior counsel with the answer, but I don't know whether it was.
Well, who filed the motion for default? The complaint, I'm sorry, the complaint that I read had only one law firm on it from South Carolina. Is that right?
That's correct.
And is that person, I assume, is a member of the Massachusetts Bar?
I would assume so, yes.
Okay. And are they the people who also filed the motion for default?
Yes.
And are they the people who were on, is there any record that the answer was addressed to them?
Only what is in the record appendix that counsel identified to you earlier of a letter being sent with a copy of that answer with no counterclaim.
Was there any discussion?
Whether it was actually sent or received.
Say that again, I missed that, I'm sorry.
That's okay. I just, other than what's in the record, I don't know if it was ever actually sent and received by prior counsel.
Did you ask?
I personally did not ask.
Because it seems to me that when you're dealing with a pro se litigant who showed up and responded in court to an attachment request to file a request for a default judgment under circumstances where you know that they've tried to answer because you've received it is a little bit questionable, isn't it?
Well, I would have to say there are instances that I see in the record where Mrs. Brown says she did something when it didn't happen. But I can't tell you.
Fair enough, counsel. Fair enough. And I'm not questioning that. I'm really asking what the facts are. Where I started with your opponent and said, where in the record can I see that? He's now shown me something in the record. I don't know exactly what it means either, which is why I asked you.
And it's a fair question, and I think your point is well taken. And here's what I guess what I would say with it is back at that May attachment hearing, if you look at the transcript, which is part of the record, there's a colloquy between the Superior Court judge and Mrs. Brown that's very telling. He specifically tells her, you understand that you have to file an answer with the court. She affirmatively answered yes, and that came up twice during the hearing. Then after that, if you look at the sequence of events, there's no response by Mrs. Brown to the notice of the request for default. There's no response to the notice for request for default judgment. There's no response to the notice for the hearing for the request for default judgment. There's no attendance, note, contact, letter, nothing as to the notice, as to the default judgment hearing in October. There's no response to the decision issued in October of 2016. There's no response to the execution issued in December of 2016. It's not until June of 2017 when she files the motion for relief from judgment. And at the hearing, you'll see at the 60B hearing, the trial judge had indicated comments in his discussions with Mrs. Brown during that hearing where he was significantly troubled and did not believe that she had acted properly or timely. Now,
Did she say to him, and I apologize, I should have read the transcript, but did she say to him, I sent an answer to opposing counsel?
I don't have that clear of a recollection of that, Your Honor.
My question really is, did that play out in front of the judge, and how did it play out? And if your answer is I can't recall, that seems to me to be totally reasonable, counsel.
Yeah, it didn't play out. I know it was of no, whether she may have mentioned it in one of her comments, I just can't recall. I don't recall it specifically, and I apologize for that.
But she did mention that there was a lot of conversation about her husband's illness. He was dying. There was conversation about her own time, I believe, in the hospital. There were a number of factors stated that weighed in favor of a finding of excusable neglect. So, you know, in either case, that gets to my next question, which is, I agree with you that the judge here was well aware of the record, issued what I think were reasonably comprehensive findings, and he was truly trying to strike a fair balance. With that said, what case or what authority says that a condition like this may be imposed? I can't find any Massachusetts or First Circuit cases where this type of condition or a parallel condition remotely approaching this has been found, number one, has been used, and number two, has been found to be reasonable.
You know, my review of the case law didn't reveal anything of that specific. This is a very fact-specific kind of enterprise as far as deciding what conditions to impose. Certainly fees can be imposed, posting a bond. There is a case that required curtailing of interest. There was an older case struck a counterclaim, and there was one with statute of limitations striking, but those, I'd have to say, were very specific to the facts before them. And to answer your question, while there was some proffered justification for this extended delay, you note what the judge said. He understood that Mrs. Brown offered that she had her own health issues. And he said, well, to an extent at least, she had offered that as an excuse. But he also noted that there was no detail, no detail as to that disability. The duration of it wasn't specified. The record shows no medical record supporting it or any independent support. And in addition, the reference to the disability of Mrs. Brown was she had to go to the hospital back for a day in July of 2016. And why I'm raising that is, while he recognized it as a justification, there's a degree. This whole sliding scale, the delay, how much delay? Meritorious, how much merit? The justification of delay, how much justification? And while he was balancing all those, the delay and the justification were not particularly whelming. And that's why I think it's important. You can't separate his decision to vacate the default from the condition, because I don't think if he thought or understood that imposing this condition was somehow invalid, that he would have vacated this judgment. As to the merits of Mrs. Brown's claim, again, I think all that's in the record was he referenced the prior judge's note at the attachment hearing that there was some possible meritorious defenses in the form of Mrs. Brown claimed that her husband had dementia and the quality of care claims. And also was referenced that the court at the attachment hearing had referenced that the wrong agreement had been submitted. Well, that had been corrected by the time of the Rule 60B. And as to dementia, nothing in this court's order regarding the default removal precludes her from arguing that her husband had dementia. It doesn't really address the fact that services were provided. And that the failing here was the failure of Mrs. Brown to follow up with a mass health application.
Let's talk about the claim that she did bring. Did your office defend that?
It did.
Was that dismissed with prejudice?
It was.
How do we know?
In the addendum to our brief at page 54, you have the court's endorsement, the Superior Court's endorsement on the defense motion. You can take judicial notice of the docket of that.
Right, but that's a dismissal, but how do we know that it's with prejudice?
Because the notion of the endorsement says the complaint is dismissed in its entirety for want of prosecution, and judgment shall enter for the defendant on all counts. So when there's a want of failure to prosecute, that's an adjudication on the merits.
Got a case that says that?
I believe there's cases that say that.
Because the first reason that was given in your motion to dismiss was that she wasn't the proper person to bring the suit. And that would not be an adjudication on the merits, it seems to me. And since I don't have the rest of the record, I don't know what the other arguments are that were made. But what you're saying is, see, if every argument that's made there is a non on the merits argument, I'm not sure he can dismiss it with prejudice.
Well, he can independently dismiss it where she doesn't abide by court orders to show up for a hearing. There was more than one motion to dismiss. A co-defendant filed a motion to dismiss for failure to post a bond, no tribunal, as a medical malpractice claim. And that court set up a hearing on those motions to dismiss. Mrs. Brown did not attend.
I was going to ask about that. So was there a co-defendant that was a medical provider?
Yes.
All right. Why don't the tribunal rules apply to your client as a nursing home?
They may well, if as far as medical care, there just wasn't any tribunal or offer of proof ever made, as far as that I understand.
Okay.
I think trying to answer your question, Your Honor, is that while there were various reasons made in the respective motions to dismiss, the dismissal was the failure to attend 2 court-ordered conferences, and there was a want of prosecution. That's an
I
adjudication.
understand your point, counsel. Thank you.
And I think it's a kind of a curveball in the case because it sort of moots this whole issue you're faced with as to the validity of this condition. Let's say you just independently look at it, determine, well, you know, that probably shouldn't have been done. You remand it back for what? This is given her conscious decision to file a separate suit and pursue her affirmative.
Your brother says in response to this argument, hey, res judicata is not a guarantee. Res judicata is an equitable doctrine. What do you say to that?
Well, it may be an equitable doctrine, but on the facts before us, she affirmatively filed this suit. She had an obligation to bring any and all claims related to it. She picked the claims that she wanted to. And as far as the principles of res judicata, it seems a classic application of it. I don't know what equity factors would militate for her to be excused from that.
Let's leave that to one side. I understand that argument. Let's just play out the procedural aspects of what your brother says. You say there is no reason to, even if you conclude that error occurred here under Rule 60, there is no reason to remand because the condition imposed is no longer relevant. Her lawsuit has been dismissed and is subject and therefore is barred, right? That's your argument.
I agree.
And I'm sorry, I don't know where to go with that. I'm just thinking.
Yeah, no, it's a curveball, and I suppose, Your Honor, in openness, that if there was concern, it would have to be a factor the trial judge would have to consider if you were to have issues with what he did with the default judgment. But I think in the end, what I'd like to conclude with is
actually don't conclude just yet. I have 2 more questions for you. So, first one: do you agree with your brother that the counterclaims in this case were compulsory counterclaims, or we should say would have been compulsory counterclaims.
I believe they probably would be.
Okay. My final question is, you've already acknowledged that there doesn't seem to be any case law, understanding that it's fact specific, you've acknowledged that there doesn't seem to be any case law addressing any sort of condition like this in this context. So are you saying this is an issue of first impression?
I don't know if I go that far in the sense that I think when you look at the case, the reason he imposed this condition is because in looking at all the factors and all the specific circumstances of this case, he was trying to be fair to both parties. He really didn't see a great justification to removal, and he thought the way to balance things out was to impose this condition. He could have awarded fees, but he knew that she had some indigency claims. So imposing a fee to pay the fees for the cost for the delay was not really something that was receptive. He could have ordered the posting of a bond, but he was concerned about imposing that. So what he thought was the one asset, even though of limited value and not well articulated, were her counterclaims. And he decided, you know, one way to resolve this, I'm going to give her the benefit of the doubt and open this up, but I'm going to limit those counterclaims to the value of the claims of Care 1, which he found to be substantial. And I think
I'm going to have to stop you right there because your time's up. But first, let me check. Justices Englander and Hand, any further questions?
No, thanks.
I don't. I just like to say you guys both did a nice job. Thank you.
And I did interrupt you, counsel. You said you had something you wanted to conclude. I'll give you 15 seconds if you'd like.
No, I think you have a great grasp of it. And I would say this, the court personnel that were responsible for the technology here, I had a practice session, they were truly outstanding. And it's just a reflection of what great people you have working for the court. And I just felt strongly enough to say that. And I'm sure my counsel, Andrew, would agree with me.
Absolutely.
Thank you.
so
We
much.
agree. Thank you both for your helpful briefs, your excellent arguments, and the cases.
All right, we are all set. We're streaming.
Wonderful. Good morning, counsel. I will remind you that this proceeding is live, so anything said during the proceeding may be overheard by all of those observing and will be seen by any observers of the court's YouTube channel. And the proceedings are being recorded, and courtroom decorum rules obviously still apply. So with that said, again, this is 19P 919 Henry versus Bozzuto Management Company, and we will hear first from counsel for the appellant.
Good morning, Justices. Orestes Brown for the appellant.
Morning.
We're here an appeal from a decision that fundamentally dismisses the putative class action and the class representative's individual claims as moot by reason of defendant's tender of full damages. The lower court, in dismissing the case, cites to the authority and reasoning of Phillips v. Equity Residential and Cole Silver Lake Motors to support its decisions. Both those cases involve the mooting of claims by the tender of full damages. On this reasoning, the recent SJC holdings of Gamella v. P.F. Chang are absolutely determinative and absolutely mandate reversal of the lower court on the two clear principles iterated in P.F. Chang. First, a defendant may not moot the claims of either the individual representative of the class or the class by tendering full damages. As the SJC said in Chang, under the basic principles of contract law, the suit of a plaintiff who rejects a defendant's offer of judgment under Rule 68 is not rendered moot because the parties remain.
Okay, counsel, but that argument assumes that you have a class, right?
It doesn't
That
actually.
is really based on the assumption that there is a class claim. Here, your class action, your class cert motion was denied. Does that make a difference?
No, Your Honor. The SJC, in Chang, the SJC specifically said that even if class certification is not made or even denied, that that you cannot moot the individual claim, and the class claims remain alive on appeal.
The class claims
can-
remain alive on appeal as long as the motion for class certification should have been granted. But if we reach the conclusion that the motion for class certification should not have been granted, or put more accurately, was properly denied, then your reliance on Gamella, it seems to me, becomes much less important. You've got your money for your individual plaintiff.
It does become less important, certainly, Your Honor, if the class is properly denied. But it's clear that the SJC has said very explicitly, in conformance with the holdings in the Supreme Court of the United States, that a rejection of an offer, even if it's full damages, does not moot the case. And I don't see any other way to
But
read.
let's talk about whether or not you should have your class certified here. The argument being made in the briefs below is that you haven't shown any of the requirements of class certification, in particular, numerosity.
Well, Gamella is instructive on that as well, because that was the issue before the SJC in Gamella, numerosity. And of course, the lower court did not give its reasonings for rejecting class certification. And in referring us to Phillips v. Equity Residential in the Silverline case, we can only assume that certification, I think it's fair to assume that certification was denied because the court felt the claims were moot. And I believe
we can
that's
affirm on any ground raised below and supported by the record.
I'm sorry, Your Honor?
We can affirm on any ground that was raised below and is supported by the record. So at least for now, I would like to, until my fellow judges push me off it, talk a little bit about class certification. What is your evidence that there is anyone else in this class besides the named plaintiff?
Okay, I'd like to, okay, so I'd like to start with the burden at the class certification, as stated in Gamella, is a different order than the parties' burden of proof at trial. So we have a much lesser burden. Neither the possibility that a plaintiff will be unable to prove his allegations, nor the possibility that the latter course of the suit might unforeseeably prove the original decision to certify the class wrong, is a basis for declining to certify a class which apparently satisfies the rule. Now, in this case, practically, so that is the standard set out in Gamella.
Don't you have to put in some evidence?
We did put in evidence, Your Honor. So in this
What's
case,
your evidence that there's anybody else in this class other than the named plaintiff?
well, we have the Bozzuto form that is safe to assume that we didn't get to take the deposition, which is also an unfair burden to put upon us at that stage. So we have a form that they admit was a form. There's a form that Bozzuto uses to provide a statement of damages when Bozzuto retains deposits for damages inflicted by their tenants. And that form is not sworn to under the pains and penalty of perjuries. I think that it is fair to infer, especially at this level where we have been refused any kind of discovery. It is fair to infer.
Can I stop you there then? Because there's something I don't understand about the record. I saw that you didn't get your deposition, but the stipulation contemplated a production of documents and interrogatory answers. Did you not get document production and interrogatory answers before class cert?
We got document production with respect to only the named plaintiff.
And that was what the agreement was on the discovery stipulation. You limited by agreement the discovery at that point to individual plaintiffs, correct?
I believe that the court required it, but that was the stipulation, that we would get the individuals, and we contemplated I certainly contemplated a deposition, but the defendant then took the position that because we had not specifically agreed to a deposition, they sought a motion to quash. You know, where it was a stipulation entered into the hallway outside the housing court, and I had no idea that there would be an assertion that somehow we were waiving our right to a deposition. And also, judges, think about this. We have a very large, admittedly large property manager using a form. And here the court has allowed them to thwart a really a pretty simple issue by refusing to produce really any documents or give us any.
Counsel, I hear you about how this was a stipulation made in the hallway and things like that, but these are serious cases. If you say there are thousands of plaintiffs involved, there's a lot of money at stake if that's right. It's your job as the plaintiff's counsel to put together a case, isn't it?
It is.
I'm looking at the stipulation. I don't see anywhere in the stipulation that it is limited just to the named plaintiff. Maybe I'm misreading it. Oh, wait, I'm sorry. Yes, it is just for the individual. So you agreed to sorry, Judge Hand. You agreed to limit your discovery just to the named plaintiff.
Well, without prejudice.
How does a court certify a class, what comes with certification of a class, as I hope everyone knows, is an awful lot of expense and effort to identify everyone who needs to be notified, notification to everyone, issues then that arise with respect to who's representing all those people and how their claims can then be adjudicated. If all of that has to happen, it's not going to happen based on, it seems to me, an inference that you want us to draw. There has to be something that tells us there's more people.
Well, what you see, the stipulation is without prejudice to class-wide, discovery.
If a class is certified.
Right, post-certification. And we felt that on the issue of the form at a deposition, we would be able to show that that form was habitually used for all of the tenants. It would be a rather simple matter. And so, having been denied
You contemplated, what you're telling me is when you entered into the stipulation that you would only do documents, interrogatories, and requests to admit for the named plaintiff, that you contemplated doing the deposition that you ultimately noted.
Denied, yes. Absolutely.
Extensive class discovery in it, but without any documents?
All we needed was that form. We only needed to inquire as to that use of that form. That was the gravamen of the entire case. That form not being sworn to under the pains and penalty of perjury and being generated. We have some experience with these cases, Your Honor, and the Yardy system we recognize as being the typical system used by these types of firms, and we recognize the form. And so,
Attorney Brown, since our review is de novo, let me ask you a question along slightly different lines. In order to obtain class relief, before you get there, first you must show that your named plaintiff meets the elements of the claim. Here, I'm thinking about 93A, correct?
yes.
Okay. So 93A requires not only a violation, an undue or deceptive act, here it's failure to comply with the security deposit statute, but it also requires causation and injury. What was the specific injury to the named plaintiff?
Retention of their security deposit.
Okay, so that constitutes a violation. But insofar as you drafted a demand letter and in response you received 3 times the security deposit, what does that do vis-a-vis the allegation of injury?
Well, that's what Gamella addresses. Fundamentally, Gamella says you can't buy off the class by buying off the class representative. That's fundamentally the holding of it. The SJC and the Supreme Court of the US has taken the position as a matter of public policy. They don't want defendants in these circumstances to be able to dispense with the class by buying off the class representative.
I understand that, but the purpose of the settlement offer, the demand letter and the reasonable settlement offer process is to cut off litigation before it launches. And so if that's a reasonable settlement offer, in other words, if your client was made whole and then some prior to you filing the complaint, how can that individual plaintiff still demonstrate injury? Do you follow my question?
Well, they can, according to the SJC, they can demonstrate injury because they have not accepted the resolution offered by the defendants. So the parties remain adverse. She's not, my plaintiffs are not made whole because they have not accepted that tender. They don't have
Gamella
that.
a 93A case?
I'm sorry, Your Honor.
Is Gamella a 93A case?
It is a 93A case, which is a much relaxed standard for certification. And the whole public policy behind it is designed to prevent exactly what's going on here, I submit. That we have spotted that it's highly likely that this unsworn to statement of damages is being used essentially to fund the renovation of apartments at tenants' expense. So
Let me ask you this, counsel. The way I read your complaint, the claim was a technical claim. It was, you didn't provide us with the damages itemization in particular that was required by 186 section 15B4, I think. Do you also claim that the damages that were asserted against your client by Bozzuto were wrong?
yes, Your Honor.
Okay.
That's the gravamen really of the case, that these are fabricated damages. That the damages to the apartment, our fundamental case is that the damages to the apartment they claim are simply reasonable wear and tear. And they are attempting to take a simple, reasonable, normal wear and tear that's expected with reasonable use of an apartment. And they're saying, oh no, that reasonable wear and tear is really damage that has to
The
be.
argument you're making now resonates with me, but I can tell you that I read every piece of paper that had been filed below and on appeal, and I did not get this argument from it. I thought you were making a technical argument with respect to the documents themselves.
No, I believe we make that argument. We made that argument consistently. That was always our argument, that that the violation of the statute is really violating the exact harm that the legislature was seeking to prevent, which is having landlords take a reasonable wear and tear of an apartment and foist the expense of curing that upon a tenant unfairly. I believe that we've always made that argument. That's
Had
been,
had the landlord here immediately returned the security deposit, but did not provide the itemized list. Yeah, let's just leave it at that. Would you still have a viable claim, and would you still have a viable class claim?
I'm sorry, Your Honor, I just want to make sure I understand that. You're asking if they
If
had.
I'm sorry, if the landlord had, in this instance, immediately returned the security deposit, but failed to provide the itemized list required by the security deposit statute along with it, would you still have a viable claim, and would you still have a viable class claim?
If they had immediately returned the security deposit, that we would not probably, no, we would not have a claim because there would be no reason to provide. It would not have triggered the requirement of providing the itemized list of damages because they'd be claiming no damages. They'd be returning the entire deposit. You only have to itemize damages if you're claiming that there are damages and you're retaining the deposit as a result.
Your claim fall under section 15B6B or 6E?
It's B, and I believe that Phillips v. Equity resolved the issue of whether it falls under. Oh no, I believe it falls under both. So if you
That's what I'm
don't,
hearing.
right, it falls under both.
Does
So
your
if you
complaint
don't,
say that?
I'm sorry, Your Honor.
Does your complaint identify which subsections of section 6 it is going under?
I don't have the complaint.
I do. I'll find it. That's all right.
But could I ask just one question before we wrap up? And that is, Mr. Brown, if you took the class component out of the equation, what damages, understanding your client has not accepted the offer that was made for treble damages plus interest, what additional damages are there for your client to seek? What's left to litigate?
Really outside the class, I don't believe there would, if they're giving us triple damages, and I believe they actually stated they were going to pay reasonable attorney's fees up to the filing of the complaint. That was in their summary judgment motion. So I don't believe there would be other damages.
Thank you.
All we've asked for is injunctive relief so that they don't do it again. So there's a question as to, well, I want to be very careful about that. They do have, according to both the SJC and Gamella and the Supreme Court, we do retain an interest because of the class in sharing fees. That's an individual interest.
Okay, I'm going to have to cut you off right there unless Justices Englander, Justice Hand, any further questions? Any further questions? Excuse me. All set. Thank you, Mr. Brown.
Thank you, Your Honors.
We will now hear from counsel for the appellee.
Thank you, Your Honor. Donna Ashton on behalf of Bozzuto Management Company. May it please the court. Your Honor, I would first like to address Judge Englander's question with regards to what subsection of 186 section 15B that this case was brought under, and whether or not it was under 16B6B or 16B6E. And I think that the Phillips case, which did come out after this complaint was initially brought, clarifies, and it does intertwine, clarifies the distinction that if you have a violation under 6B, which is a documentary violation, which is almost identical to what we have in the facts of this particular case, that you can't then bootstrap the 6B argument into the 6E argument, excuse me, into the 6.
I understand that point, Your Honor. Sorry, Your Honor. I understand that point, counsel, but I read the complaint and I think you can read it to be different than just a documentary allegation. I mean, by failing to return any portion of the security deposit within 30 days. That's count 2, paragraph 61. Why doesn't that also encompass section 6E?
Well, Your Honor,
what Counsel Brown says.
It is, Phillips is very specific, and the facts are quite similar, that was exactly the same happened factually with Phillips. So Phillips said that if they didn't return it, and it was again and under the pains and penalties of perjury, a non-itemization of the damages and failing to provide those documents in support, that triggered just 6B and not 6E.
I'll have to read Phillips, but I have to tell you, I read it yesterday, and I don't think I fully understood this distinction. But if his allegation is, look, you held on to a security deposit you were not entitled to, and if that's the allegation, isn't that E? That's exactly what E is.
Your Honor, though, that needs to actually be pled and actually be alleged in order for him to raise it now in appeal.
By failing to return any portion of the security deposit, paragraph 61. Now, if what you're saying to me is he didn't make that argument below.
He didn't make that argument below, Your Honor. But he also, the only argument that this case comes from below is his allegation that it's a per se violation of 93A, which we've briefed and which we've gone through, which is not enough. And that has been our allegation or our contention all along, that you need more than just the violation itself. You need, and the courts have said, and Tyler has said, you need a separate identifiable harm arising from the violation itself.
The injury is you had my money for a year. Isn't that an injury?
Well, I don't think that that's an injury that
Why not? Isn't that exactly why they want you to give the security deposit back, so you don't get the use of it?
But then we also look to, and what my brother has failed to address in any of the memorandum is with regards to the security deposit case law that has come down with Katz and Holtz and Taylor and Hara.
Cases address this argument. He's saying The 93A violation is per se because you didn't give, let's leave aside the question, a separate question of whether there's a claim we should have gotten our money back, and simply rely on the documents for a moment, okay? He says that's a per se violation. You didn't provide detail. And isn't, by the way, isn't he right about that your client violated 186.15b?
We can see that it didn't have under the pains and penalties of perjury. And we also
Also didn't particularize the damages.
we particularized the damages 3 days late. So this was, this was supposed to be, yes. So 3 days late, when we were asked, we particularized the damages.
And,
so, and then
the regulation says that's a violation of Chapter 93A.
the regulation says.
Do you challenge whether the regulation can say that?
I challenge that there needs to be a harm to the individual, to the plaintiff, in order for them to have a violation of the
Separate issue. First question, is there an unfair and deceptive trade practice? The regulation says not itemizing the damages is an unfair and deceptive trade practice. Do you challenge whether the regulation is within the authority of the court, within the authority of the Attorney General to make?
I think that the Attorney General can make the regulation, but I think it's the plaintiff's burden to prove that they actually had the injury.
Right, I agree with that. That's a separate element. He says the injury is you held on to my money for a year. Is he wrong about that, and why?
He's wrong about that because I think that if we had known and we were given the demand and the request, as what the case, the Taylor and the Katzenholz and the Carr case say, that if we were given the demand and we returned it, then that would be the acceptable remedy for this individual plaintiff, which we did.
No, you have the security deposit. You have a bunch of rules you have to follow. You didn't follow them, and you didn't give them the money back for a year. How is that not injury?
That's because we didn't know that there was an issue with it for that year. So we were asked to return we were asked for the itemization, and we were asked for
It's his job to tell you you shouldn't be holding my security deposit.
I'm sorry, what?
It's the job of the tenants to say you shouldn't be holding my security deposit?
No, but it's not also the intent of the statute, and what the Katzenholz case, which was also supported by the Phillips case, says they declined to construe 15B as a minefield of potential multiple penalties. So when we know about what the error is, we return it. When we knew about that there was a demand, even though it was a year later, the only reason we knew it was a year later was because that's when the demand came in. If at the time the demand had come in at that same time that he was asking for documents and he had some issue with them, then we would have addressed it at that point in time, but it wasn't. It was just asking us for the documents, and they were provided, again, 3 and then 7 days after when the deadline was. This is not an unscrupulous landlord who is trying to take and as alleged now on appeal, is somehow trying to manipulate the security deposit to fund their capital improvements. This is a landlord who provides quality housing for tenants of the Commonwealth. They made a mistake and an error, and under the case law, they're entitled to return that prior to have an onslaught of litigation, which would be costly for all of those tenants that they have.
It strikes me that if they're a scrupulous landlord who follows the rules, then it would be relatively simple for them to itemize the damages, in particular, as required by a statute that they must deal with many, many times a day. And they failed to do that.
Your Honor, they did itemize on the return. They just didn't provide the enclosed documentation.
They said for damages.
They said for cleaning damages and for a carpet replacement. So
that was on day 37 when asked, is my understanding. My understanding is the first thing they did is say, you owe us $100 or $200 for damages. No itemization whatsoever. Am I misunderstanding the record?
there was itemization in the attachment to the letter. It was not specific to what that 1260 was. When they asked what the 1260 was, that's on.
Right. So if I'm a regular old tenant, which I have been, and probably all of us have been at some time, and I give somebody a security deposit of $1,100, I don't want to get something that says, you owe me $100 more for damages. I want to get what the statute requires, which is, here are what the damages are, and here's how we calculated it. And if your client is a scrupulous landlord that does this thousands of times, I don't understand how they couldn't follow that.
Your Honor, the issue is with regards to the timing and the 3 days and the 7 days. And there are times when things don't come in exactly on time to be available to provide that information, but they did when asked. It wasn't, and the documents that they attached even show that they replaced the entire carpet because of these damages, and they also had a cleaning charge, which they didn't deduct from the security deposit. So they did do what they were supposed to do, albeit in this one particular case, late. And I would take also issue with the fact that my brother keeps on saying that this is a form, calling it that they use it at 6,000, at least in his allegations. There's no support in the record. There's no actual evidence that that is the case. It's merely that, as my brother even stated, that I assume I'm familiar with this process. I'm familiar with how this works. There's nothing in the record in the complaint that actually upholds that or that supports that assumption on his part. And my client is entitled to have those allegations spelled out in the complaint, and if not, is entitled to the summary judgment. And if there is no real injury, with which I think the Phillips case supports in terms of the injury aspect, then the forfeiture of the deposit is the only remedy, which was done also prior to the complaint being filed, so prior to litigation ensuing. And that is what the judge rested his, from his order, it appears that that is what he rested his opinion on, that it was a return of the deposit prior to litigation ensuing, and that there were no other injuries. And if there are no other injuries, in order to have a class and in order to have a claim under 93A, you need to have an injury. You can't separate that out.
You haven't yet satisfactorily answered for me why it's not the injury that he identifies, which is the most obvious injury. You're holding his money, so you need to pay the cost of holding the money. I mean, the whole purpose of the statute is so that you don't hold the money longer than you're supposed to. You, according to him, he has alleged that you did.
I don't believe, though, that, so when you look also at 186 15B, there are other sections, and 186 15B 7 is the one that triggers treble damages and talks about the relief and also attorney's fees for violations. So Phillips also talks to this, that the legislature has enacted and has looked at what the violations are that would be so egregious that you would get the treble damages and you would get the attorney's fees.
I understand
and
this.
That would not be.
I'm confused about one thing. I understand this point. If his claim was solely a documentary claim, then he doesn't get treble damages. And if his claim was solely a documentary claim, then it's hard to see how the injury that he's now talking about is related to the documentary claim. Because it's not a claim, hey, you shouldn't have been holding my money. It's a claim that's purely technical. You didn't provide the proper documentation. But he is saying that he has a claim that you shouldn't have been holding the money because the damages were improperly asserted.
But
you follow what I'm saying?
I do follow what you're saying, Your Honor, but that has never been alleged prior to today. So that's not in the record. That's not in what he's briefed. That's not in his reply brief. That's not what he's asserted. And if in fact that is what he asserted, I think that the reason why he's not asserting that is because then it would be difficult to have a class based around that, because you wouldn't be able to have the
similar injury.
What?
You wouldn't be able to show similar injury.
Correct. So that's why he's framed it the way that he has. So if he has, then you have to prove what you framed. And if you can't prove what you framed, then you're not able to bring the class, and you are subject to summary judgment on the 93A, and you have been given the return under the 186.15B. So the 2 counts that remain should have been dismissed on summary judgment. And the court, even though it was very short, pointed
Wait a
to.
second, isn't it right that they shouldn't have been dismissed after Gamella? They're not moot.
Your Honor, I wouldn't say that. So in order for you to have, it's not a matter of even mooting, it's a matter of the return prior. And in Gamella also, it talks about under similar practices of there remains parties that are adverse. And I would suggest that the parties are no longer adverse once they're returned a full deposit, returned 3 times the amount, which we did that prior to the Phillips holding. So at this point, they're getting the benefit of 3 times when it really should just be potentially the return of the deposit prior to the complaint. So if you do those things prior to litigation ensuing, following Katzenholtz and Cara, then you would not be presently adverse. And with regards to that Gamella case, it also talks about potentially having it be a tender that's rejected. But if you look to that, it talks about principles of contract law. And my argument would be that in this particular case, you have holdings of Massachusetts appellate courts, which specifically talk about what needs to transpire and what needs to happen when there is a violation, even a technical one. It's the return and the forfeiture of the deposit, and it's not this pillory of multiple damages.
Thank you, counsel. Your time has expired. Justice Hand, any further questions?
No, thank you.
Justice Englander?
No.
Thank you.
both. We appreciate the extensive briefing on this case and the excellent oral arguments from both counsel. Thank you very much.
Connect to live streaming. Hang on one second.
Yes, ma'am.
All right, we are live.
Okay, good morning.
Good morning.
I will remind you both that you each have 15 minutes to present argument. There is no rebuttal in the appeals court. I will also remind you that this proceeding is live, so anything said during the proceeding may be overheard by all of those observing and will be seen by observers of the court's YouTube channel. And the proceedings are also being recorded. So with that said, we will hear first from the appellant. I believe that's Mr. Abrew.
Yes, sir.
I'm sorry, go ahead.
I don't mean to interrupt, Your Honor. The appellant is Ms. Delgado.
It's Ms. Delgado. My sheet has it, or I read my sheet incorrectly. Sorry, we'll hear from counsel Heather Jill Williams. Thank you for correcting me, counsel.
Good morning, Your Honors. If it may please the court, I have to remain sitting during the presentation. I don't have the capability to film while standing, so I hope that is acceptable. So this appeal was filed on behalf of Sageti Delgado. She is a mother of a child who at the time of hearing was 3 years old. She and the father had never been married. I was not present during any of the lower court proceedings, and my appeal is based solely upon the record as it exists. A review of the record indicates that there was a calamity of errors that began with the very filing of this matter in the Commonwealth of Massachusetts. It appears from a review of the record that Mr. Abrew initially filed with the Probate and Family Court in Springfield, Massachusetts. Upon filing any action for custody or parenting time, a parent is required to file an affidavit disclosing all care and custody proceedings. He did do that care and custody affidavit, which is signed under the pains and penalties of perjury. And that, Your Honors, is reflected in the record as the appellee, the appendix, page 10. On that care and custody affidavit disclosing all proceedings, Mr. Abrew did not disclose that there was, in fact, a pending action in the state of Rhode Island. It's a little unclear because he lists that DCYF in Rhode Island is an interested party. He started to list that there was an action pending and then he crossed it off. So the matter goes forward within the Commonwealth of Massachusetts. It appears from the record.
I'm sorry to interrupt you, counsel, but on June 8th of 2018, the Rhode Island court terminated that matter, correct?
That is not clear. the parties say at some point that the matter closed in Rhode Island. However, there was never anything filed in the Commonwealth Court showing whatever was pending in Rhode Island. What was that, akin to a care and custody proceeding? Was it simply there was never an action filed in the state of Rhode Island in their court system? Although I do have reason to believe that based upon Mills Delgado's affidavit, there was an actual court case. None of those records from Rhode Island were ever presented to the court in Massachusetts, although at some point, seemingly after our court made orders, the Rhode Island case ended.
I'm looking at page 4 of the supplemental appendix, which appears to be an order from the state of Rhode Island. This is the ex parte motion to amend order, which states in relevant part on May 14th, 2018, the court entered the following order that the within DCYFK shall be terminated without prejudice on June 8th, 2018.
Correct, but that was presented pursuant to the supplemental appendix that Mr. Abrew filed with this court, Your Honor. That was not filed in the lower court. That's not part of the lower court record.
Are you disputing the accuracy of that document?
I am not disputing the accuracy of the document. I'm disputing the timing of how everything went in this case.
But now we're into the area of what do we care, right? I mean, let's assume that everything you've said is right and that the court, although I thought I saw somewhere that your client disclosed to the court the existence of custody proceedings in Rhode Island, right?
She did, Your Honor, yes.
Okay, so the court goes forward and it turns out that by the time the court enters any orders, the proceedings in Rhode Island have been terminated. Why do we care then?
So I think that that is not correct. I think that the court in Hampden County entered the very first substantive order because the court did notice that there was some sort of jurisdictional problem. When this matter was first scheduled, they took a step back and said, wait a minute, I want both parties to file affidavits about what exactly is happening in Rhode Island. I'm not going to do anything on this petition. So that happened. And then the record is not clear to me.
Well, wait a second, I'm sorry. That's even news to me since I read the briefs. So how do we know that that happened in the Massachusetts courts, and how do we know what happened in the Massachusetts courts?
So we know that that happened in the Massachusetts court because in the appendix, if I can just have one moment, on March 29th, this is appendix page 20, the lower court enters an order that indicates that after review of the motion, it is ordered that they need the following information: the date the father moved to Massachusetts, if there were any cases filed in any other court, including docket number and the status, and the hearing that was initially scheduled for April 2nd was canceled, and it was scheduled for review on April 23rd, ordering that both parties are to file affidavits with the lower court in Massachusetts, stating what was going on in any other courts, and that then they were going to report to probation on April 23rd, which I'm not sure why, because it doesn't reflect in the lower court. The April 23rd date did not take place either.
So you have an order which says, provide us with the status in Rhode Island.
Correct.
What happened with that? Do we know?
We do. So then both parties, and this is docket number 23 on behalf of father and an appellate court record number 24 on behalf of mother, both parties file affidavits with the lower court, father on April 2nd and mother looks like on April 13th, indicating that there was an action pending in Rhode Island, and they both indicate that there's a further hearing. Father says there's going to be a further hearing on May 14th, 2018. And mother indicates there's going to be a further hearing on May 7th, 2018. And both affidavits are signed under the pains and penalties by both parties.
So
Let me ask you this. What is the date of the order before the Massachusetts court that you are presently appealing?
The date of the Massachusetts order that we're presently appealing is the judgment that entered on the whole action, the custody, support, and parenting time, that entered on, if I just may have one moment, on December 11th, 2018. And why the history is very salient.
Let me just stop you there. So if the Rhode Island court terminated its case in June of 2018, why does this case not fit under General Law, Chapter 209B, Section 2, B4D, subsection 4, which states in relevant part, or otherwise defer to the jurisdiction of the court of the Commonwealth. So in other words, there's a lengthy process, if you will, in 209B, 2B4D, which you cite in your brief, describing all the ways in which a Massachusetts court shall have jurisdiction. And one is in the case in which a court with another jurisdiction, here Rhode Island, says we will otherwise defer to the jurisdiction of a court of the Commonwealth. Why is that not the situation that occurred here?
Because because with all due respect, we have no evidence that at any point in time there was ever an interstate conference between the two judges. We have no evidence that there was ever a ceding of jurisdiction. That's not anywhere in the record.
What about
But the Rhode Island case was terminated prior to the Massachusetts court executing the order that you are now challenging.
Well, so here's where the problem comes in, Your Honor. So the court in Massachusetts on June 4th, 2018, before the Rhode Island court closed their case, they entered the temporary order. That then, when we get to December, the court says, I'm not going to change my temporary order because there's been no showing of a material and substantial change in circumstance. So the 209C statute is unique. It's different than our divorce statute. It reads that at the final hearing on a custody support parenting time, the parent has to prove that something has changed. Otherwise, the temporary order gets incorporated into the final order. So the order that this court incorporated in December, they had actually entered on June 4th before the Rhode Island case closed. So that's
counsel, I'm confused. I'm looking at the document that Judge Neyman pointed us to, which is page 4 of the supplemental appendix. And it says, order. The court's order of May 14th terminating the within case without prejudice effective June 8th is amended to make the termination date June 1, 2018. That seems to me to be before June 4th.
That is before June 4th, but all of that happened after June 4th and then had retroactive application. But when this case was pending in Rhode Island,
May 22nd, I'm very confused.
I was confused as well because the court in Massachusetts, the lower court, didn't have any of those records. Mr. Abrew provided those for the appeals court, but those were not part of the lower court record.
How do we know that?
We know that because when I went to prepare the appendix, I went to the courthouse, I pulled the file, I pulled every page that was docketed. The exhibits that are contained in my appendix are what are on file with the court. So upon my representation, I went and then I further went ahead and I spoke to one of the registrars, I'm sorry, not the registrar, but Mary Keeler, who is who handles the appeals and assembles the records at the Hampden County Probate Court. And I said, I need everything that was ever filed, docketed, put in, there's a leave with paper section with the file that is documents that are not scanned or docketed, but that are somehow put.
I don't know how you say the name, Abrew, maybe. When Mr. Abrew was testifying at the hearing in December, he references the fact that the case has been dismissed. And the judge makes a comment on the record. Yes, I see that right here.
And that's
why I asked the question, how do we know she didn't have this before her? And I understand your answer, but do you know what she was referring to when she said, I see that right here?
I do not know what she was referring to, and there was no paper record or document contained within the file at the Hampden County Probate Court that would lead a person who's reviewing this to understand what had happened. So the issue that comes up with why this is all relevant to what happened with Ms. Delgado is that her case in Rhode Island was going very well. She got custody of her older 2 children back in Rhode Island long before all of this took place in Massachusetts. And the concern is that Mr. Abrew, rather than following the channels in Rhode Island and dealing with Rhode Island to figure out what should happen with this 3rd child, he somewhat circumvented the process. And I understand that then Rhode Island entered an order and made it retroactive before the June 4th date. But on June 4th, a further problem happens that I can't tell as a party coming in after the fact. I don't know why these people were there on June 4th. The only thing pending at that time was mother's motion for parenting time and for custody. Dad didn't have a motion pending for that date, but there isn't a renotice of motion. There isn't a notice of hearing. There isn't anything docketed in the lower court that tells someone reviewing it, why were these people there that day? And when I tried to ascertain that information from my client saying, do you have a paper notice? Like, what did you get that made you go to court June 4th? She didn't have a recollection. But we know that both people were in court on June 4th. And this temporary order enters. But I have no record that this was a date that Ms. Delgado had noticed was going to be a date that she was potentially losing custody of her child or potentially losing parenting time that she had previously been awarded in Rhode Island. There's no indication as to
Is there
what.
any transcript? Did you try to get a transcript of the hearing?
I did not get a transcript of that hearing. The record shows me that mother and father, and there's a notation at the bottom, this is on page 25 of the record appendix, that there was our probation officer present. So the standard of practice in the probate and family court in Hampden County is that the parties would go in for dispute intervention and they meet with a probation officer in an attempt to figure out what to do if they can come to any agreements. And it is clear that on that day, the parties did meet with probation and they entered into this agreement for parenting time for mother without an order for custody, which then was entered by the judge on page 26. But again, I don't know why they were there. I don't know if mother knew going into that hearing that this was going to be a hearing that she had to be prepared to discuss what was going to be the parenting time, what was going to be the custody arrangement. There's nothing in the record that tells me why they were there. I tried to figure out if it was.
Did you ask for a transcript?
I did not get a transcript, no.
Counsel, let me go back to 209B, section 2B4. In determining whether or not the Rhode Island court was defer to the jurisdiction of the court of the Commonwealth, is that an issue of fact or is that an issue of law?
That would be an issue of fact. There's no, we have no, so typically in a case of this nature, there would be an order. The judge in Massachusetts would reach out to the judge in Rhode Island, either in camera or on the record. They would have a colloquy, and then there would be an order issued, a direct order, a paper order that reads, we, the state of Rhode Island, cede jurisdiction to Massachusetts, and that then gets filed with our court in Massachusetts, along with certified copies of any orders that had already entered in Rhode Island. If there already was an order entered in Rhode Island that gave dad some form of custody, I'm not even sure if Rhode Island, the state, had custody when this started. If they had custody and just placed the child with dad, that's not even clear from the record that I've reviewed. So we don't have that background in this file at all. And I'm a little, I can only speculate as to what happened because both parties have a different version of it.
Okay. Justice Hand, any questions?
No, thank you.
Justice Englander?
I did, yeah. You, I think, made a comment earlier that the procedures are such in the context of custody that the temporary order then requires a changed circumstance?
It does. That's how the statute reads.
That's how the statute reads.
It does, which was
And
interesting.
this is the statute that grants, having to do with the grant of custody.
Yes, sir.
Where
In
is
a
that?
non-married parties.
209B?
Correct.
Okay.
And I believe I cited that exact language within my my brief, because when I first started off on this brief, I thought, wait a minute, the judge made a finding that there was no material and substantial change of circumstance, but this was a case of first impression. This was the first case of assigning custody. And when I went and reread the statute, I read that that was not necessary, which was why when we go in on June 4th and there's a temporary order that enters part on agreement and part not for reasons of I'm unsure why the parties were in court, and then that just gets added on and says, well, you didn't find, there were no material change of circumstances, which I didn't even get into my argument that I cited in my brief, many material changes in circumstances that took place since that June 4th temporary order that the court did not recognize.
Thank you. Past your time, but we appreciate the argument. Thank you, counsel.
Thank you, sir.
We'll now hear from the appellee, Mr. Abrew.
Yes, sir. No, when we went to court, I got all the paperwork here from Rhode Island. You know, I don't think they did anything wrong. We went through every procedure that had to be dealt with through court. You know, I don't think the judges made any error. And, you know, I just fear of my daughter, you know, going back with her mother. You know, she's been with me for almost 3 years now. And prior to my daughter being born, I didn't know my daughter lived for almost a year and a half. And her mom has already threatened me. She got her daughter back. That she's gonna make it hard for me to see my daughter. You know, and that's just, I'm scared for my daughter. And she's saying anything about June 4th. I mean, I got all the paperwork here. You know, it says temporary order after hearing held on June 4th. Plaintiffs / fathers complain for custody support parenting time pursuant to GLC 9, at which both parties appeared self-represented. It is hereby ordered. Father shall have legal and physical custody of minor child. Joanne Abrew, date of birth. The party shall comply with terms of their partial temporary order on agreement of parties of this date. I don't know if there's any
Mr.
questions
Abrew.
you'd like to ask.
Yes, sir. You filed the supplemental appendix in this case?
Yes.
Okay. And at pages 3 and 4, there are documents from the state of Rhode Island. Those are documents that you obtained from the Rhode Island courthouse?
Those were my copies I have gotten when I went to
Those were
court.
copies that were provided to you while the case was ongoing?
Yes, sir.
Okay, thank you.
Mr. Abrew, along those same lines, one of these documents that Judge Neyman pointed out is it's a document from the Rhode Island courts, and it has a signature of a lawyer for Ms. Delgado, Donald
Yeah.
Elbert. So
Yes.
was the child's mother represented by counsel in Providence?
She did. She had she was represented by the kid's lawyer, I think it was, or something.
Okay. How old is the child now?
She just turned 4 years old.
And you've had custody of her since June 2017, is that right?
Yes, sir. She's got her own
And
bedroom
that
here.
custody came initially out of Rhode Island, is that right?
The custody came out of Massachusetts because of jurisdiction. I had to come to family probate in Massachusetts and file for custody of my child. My daughter was placed in a foster home in Rhode Island, and after that, they expedited the stuff and the procedures and all that. And then a month later, we went to court, and the DCYF came to my house, made sure she had her own bedroom and everything. And then from there, they gave me my daughter temporary custody.
Sorry, Mr. Abrew, I'm confused about something. The child was removed in Rhode Island
Yes, sir.
in the middle of 2017.
Yes, sir.
And was placed in your care, is that right?
No, she was first in a foster home in Rhode Island for
For about
almost
a month.
Yes.
And then you received custody of her after that, is that right?
Yes, sir. Yes, sir.
Who was it who ordered that you should take custody for the first time? Did that come out of Rhode Island or out of Massachusetts?
It came out of Massachusetts. They told me in Rhode Island to go to court, file for custody in Massachusetts because it's different states. And when
But
we
I
came
thought
home,
you didn't move for custody in Massachusetts until March of 2018, but that you had possession of the child, custody of the child, way back in July of 2017, 9 months earlier, 8 months earlier.
yes.
Okay, so when you first, so my question again is, when you first, I'm sorry to be, I know this is hard and you're doing great. When you first got the child back in 2017, who ordered that?
Court in Rhode Island.
Okay. Okay, thank you.
Yes, sir.
Judge Hand, any questions?
No.
Judge Englander?
No,
Okay, thank you both. We appreciate the helpful briefing. We appreciate the argument. The case is deemed submitted. Thank you both.
Thank you. Have a good day.